Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is that if the assessee does not appear before the assessing officer and the assessee adopts a policy for not appearing at the time of CIT appeal also, and if the matter goes to the tribunal and assessee seeks remand back of the matter, then whether this casual approach of the assessee can entitle him a simple remand back by the tribunal. This is the issue which has been elaborately taken by the Raipur ITAT in the case of Adim, Jati, Seva, Sahkari, Samiti, MARYADIT versus Income Tax Officer. This case has been reported in 108 ITR Tribunal at page number 645. The matter has been decided on 18th September 2023. In the present case, the assessee deposited cash into his bank account during the demonetization period, and the assessee even chose not to file the income tax return. The case of the assessee was picked under scrutiny, and when the notices under section 142 subsection 1 clause I were sent to the assessee, multiple notices were sent. The assessee chose not to give the submissions. The assessing officer does not have any option just to take the recourse of section 144, that is the best judgment assessment, and the assessing officer deposited the whole amount of cash deposited under section 69A into the income of the assessee. The assessee filed appeal before the CIT appeal. It means that the assessee got the assessment order. Now the assessee has the option to give the complete corresponding details to the CIT appeal, also to update his contact details like email ID, address also, so that all the notices can be received. But when the matter was before the CIT appeal also issued multiple notices to the assessee, and these notices were not complied by the assessee. This was the golden opportunity for the assessee to give evidences before the CIT appeal, but the assessee missed this bus also. The CIT appeal also does not have the option just to retain the order of the learned assessing officer. So the assessee moved against the order of the CIT appeal to the tribunal and requested for the remand back of the matter. The issue before the ITAT was that whether this case is a fit case for the remand back, whether the remand back is a matter of right of the assessee. Remand back is given in situations where, for the genuine reasons, the assessee is not able to give the evidences at the level of assessment proceedings or at the level of first appellate authorities, that is CIT appeal. But in this case, the facts and circumstances are very clear that the assessee, for his own volition, had adopted an invasive or lackadaisical approach before the lower authorities by not giving the evidences and documents at the appellate stage or at the assessment stage. The tribunal said that in the present case, that the ITAT forum is where the assessee feels that the assessment order and the CIT appeal order is not as per the law. So this is a forum where the assessee can come and can explain his point. But it is not a forum which should be adopted by the appellant for his own volition, and where the assessee has adopted an invasive or lackadaisical approach before the lower authorities by not submitting the documents. So in this case, the tribunal rejected the appeal of the assessee that this matter should be remanded back and reheard by the assessing officer. Friends, this case is very important because we see in our day-to-day practice that the assessees adopt a very lethargic approach, and they take as a matter of right that they will go to the tribunal and the tribunal will remand the matter. In the present case, there was huge addition by the assessing officer and the matter of the assessee was not remanded back. So we should take a very good lesson from this case that the remand back is not a matter of right. It should be given only in genuine cases. At the end of the video, once again, I am repeating the name of the case. The name of the case is Adim, Jati, Seva, Sahkari, Samiti, MARYADIT versus Income Tax Officer. And this case has been reported in 108 ITR Tribunal at page number 645. The matter has been decided by Raipur ITAT and the date of the judgment is 18th September 2023. Thank you, friends.